Besetha Sam Lotu-Iiga.
Thank you, Mr. Chairman. And while you're in the chair, just congratulations again for your promotion to Assistant Speaker. Mr. Chair, it's a real privilege to speak on this bill, and also want to acknowledge, like my colleagues, our officials who are to our left, and the work that they've put in certainly on this bill. It's been a difficult bill in terms of balancing the competing interests, and the stakeholders were quite passionate, shall we say, about each of their respective views and opinions. But, Mr. Chair, it is about balancing the rights of rights holders, and they are intellectual property rights with, as many have already pointed out this evening, the developing and changing technologies that are inherent in this technology age, particularly around the use of the internet. Sir, it is about protection of property rights, and some submitters actually compared property rights, intellectual property rights, so they are not tangible, cannot be held in your hand, with those of private property rights owners, with those of landowners, with those of certainly of those that have property rights, private property rights that we clearly understand. And in trying to protect those property rights, we must understand that investment, research and development, resources, time and energy have been put into developing rights. And it's certainly, when you talk about, in particular, the creative industries, and the time and resources they put into that, there's a huge amount of risk involved. There is risk in terms of putting monies up front, developing a product or a service or a technology, and then seeing how that product is taken to market. And, sir, if that product cannot be fully capitalised on in terms of its return, then we must have, there are questions that arise. And that was the original intent of the legislation in 1994, to protect the intellectual property rights holders, particularly in the creative industries, and balance that out with the developing technology. So, sir, if we are going to have a thriving industry, we must have laws that not only protect those rights, but make those rights enforceable in a court of law, or certainly in a tribunal situation. So the arguments that have been put forward by the creative industries was that suspension is vital as the ultimate sanction. The ultimate sanction. And one of the submissions actually talked about a number of infringements, high volume online infringements by individuals. And in such cases, a 3 strikes graduated response would in effect be useless, superfluous, redundant. And that was the submission that was put forward in terms of why suspension is the final sanction. Because there are many reported cases where infringements have been made by not just individuals but groups of individuals, and they have literally abused the file sharing technologies that are out there. So that's on the one hand. Secondly, on the other hand, we heard from a number of ISPs who, and this point hasn't been raised this evening, but ISPs talked about the implementation of this regime and the costs that would be imposed on ISPs in order to implement this regime, the millions of dollars, and we heard from a number of them who, when questioned, actually went back to their respective organisations and made an attempt to quantify the costs of the implementation. And they did come back, and the figures were quite startling. The figures were in their millions. And in terms of compliance, costs of this regime, which no one as yet has mentioned tonight, that certainly put us as a committee on notice that this is a serious... Mr Chair, if I may, Mr Chair.
I call the Honourable Member Pasata Sam Lotu-Iiga.
Thank you, Mr Chair.
Malo Soifua.
Malo Soifua. Thank you, Mr Chair. And so that is a really critical part of consideration, that we don't over-regulate, or that the regime may in fact be counterproductive to certainly to our economy. The other reasons that were advocated were that if suspension was, or in fact termination was an option, then it would penalise not just a single user or the transgressor of the copyrights, but also those other users that may be part of a network. So where a teenager, for example, was the transgressor and the account was suspended, then that account may actually service not only that teenager, but that person's mother, father, siblings, and whānau and other family members who are reliant on that account. Also, sir, the regime was seen as not just... the issue of suspension was not one of just deterrence, but also that this regime would educate those who were transgressing the legislation. And so a notice regime was important in order to send a message, and a deliberate message, if you like, to those that have made infringements, to educate them that they were in fact breaking the law. And I think this was an important part of the consideration of the committee. So, sir, I think the majority of us came to recommend the new section 122PA, which in effect brings together a workable compromise on this issue. The bill's provisions allow for internet suspension would be retained, and that this would only come about if evidence indicated that notices alone were not in fact having their desired effect. And in this instance, an order in council, the suspension provisions would be brought about by an order in council. And I think that's a fair and a reasonable compromise to this dilemma that we found ourselves in, because the competing interests, as were laid out by the various stakeholders in quite a passionate way, were quite, they were compelling on both sides. And I think we need more evidence to make a more informed and a more reliable decision as to whether suspension is in fact to be implemented. And I think my colleagues, and certainly I hear from members opposite, that is a fair and reasonable situation. Certainly stakeholders of the industry will need to monitor that and cooperate with the officials at the ministry. And I'm sure that when the review date comes in future, we will have the evidence to suggest whether such a policy should be implemented. Thank you, Mr. Speaker. Mr. Chair.
I call the Honourable